The day I decided to testify against my own father, I threw up in the courthouse bathroom first. Not from fear, from the specific nausea of knowing that what you're about to do is right and irreversible and will cost you something you can never get back. I stood over that sink with my hands braced against the cold porcelain and looked at myself in the scratched mirror and thought, there are exactly 3 people in this building who know the full truth. One of them is me, one of them is my attorney, and one of them is the man who engineered this entire thing from the outside, who found my family's fracture lines and ran a lit match along every single one of them. My name is Mara Calloway. I am 43 years old. I have spent 16 years as a covert operations officer for the Defense Intelligence Agency, and I have never once in that time questioned whether what I was doing was worth the cost. Until 8 weeks ago, when my father served me with a civil fraud complaint in Fairfax County Circuit Court, and I realized that the fracture between us hadn't happened naturally. It had been manufactured. And I still hadn't decided what I was going to do about that. Let me back up, because the setup matters, and I want you to understand who these people are before I tell you what happened to them. My father, Gerald Calloway, is 69 years old and has been the sitting chairman of the Fairfax County Planning Commission for 11 years. He is not a bad man. That's the thing I keep coming back to, the thing that made all of this so much harder than it should have been. He is genuinely not a bad man. He is a proud man, a stubborn man, a man who built his identity around a very specific image of what family looked like and what a daughter was supposed to be. But he loved my mother. He was present. He coached Little League for my younger brother Danny for 6 consecutive years, even though Danny was, by any objective measure, a terrible baseball player. He showed up. In the ways he knew how to show up, he showed up. The problem was that the ways he knew how to show up didn't include a daughter who disappeared into classified work and came home twice a year with explanations that sounded evasive because they legally had to be. My mother, Carol Calloway, died 14 months ago from a stroke. It was fast, 4 days from the first symptom to the end, which the hospice nurse told us was actually a mercy, though it didn't feel like one. She was 66. She had a trust established in 2003 that divided her personal estate between my father, Danny, and me in roughly equal thirds, with a provision that her personal savings account, about $230,000 accumulated over 30 years of careful living, would go entirely to her children, split evenly. What followed her death was a period of paperwork and grief that I navigated largely from a distance because I was in the middle of an operation I cannot name, in a country I cannot name, and I couldn't be in Fairfax County going through filing cabinets. I gave power of attorney to my attorney, Diane Cho, a woman I trusted completely, and I asked her to handle the estate administration on my behalf. She did. And at some point during that process, $94,000 moved from my mother's savings account to pay for the in-home care team I'd hired for my mother 18 months before she died. A team my father had initially agreed to, and then, when the bills came, claimed he'd never authorized. The paper trail was clean. The authorization was documented. But the timing looked, if you didn't have the full context, like a large sum of money had moved out of my mother's estate during a period when her health was declining and her eldest daughter was conveniently absent. Gerald filed the complaint in late January. His attorney was a man named Preston Holt, who had an office in McLean and a client list that suggested he operated at the intersection of local politics and private money. I didn't know much about Holt when the complaint landed on my attorney's desk. I knew more about him later. The complaint alleged that I had, through my power of attorney, improperly withdrawn funds from my mother's personal savings during a period of diminished capacity, that I had failed to meet the trust's employment verification requirement, the same clause that appears in roughly 40% of Virginia trusts drafted in the 90s, requiring demonstrable income, and that I had misrepresented my professional status to the estate administrator. Gerald, according to the complaint, was seeking full recovery of the $94,000 plus damages. Diane told me on the phone with a careful neutrality that meant she was choosing her words to manage my reaction, making public statements in county political circles that were going to be difficult to walk back. I sat with the complaint for 3 days before I called Diane back. 3 days during which I read it probably 20 times, not looking for legal strategy, but looking for something else, looking for the emotional architecture underneath the legal language, trying to understand what my father actually believed versus what he'd been told to believe. Because there was a difference, and I could feel it in the way you feel something structurally wrong in a building before you can identify the specific crack. Some of the details in the complaint were things Gerald could have known. Some of them were things he couldn't have known without help. The specific language around the employment clause, for instance, the phrase deliberate exploitation of verification opacity, was not language a 69-year-old planning commissioner came up with on his own. That was drafting language. That was someone who understood how classified employment structures interacted with civil trust law. That was someone who had looked this up. I want to be honest about what I felt during those 3 days, because this is the part of the story I'm least comfortable telling. I wasn't angry at my father. I was sad in a way that had a specific texture. The sadness of recognizing that a relationship has been damaged past a certain threshold, that some things said publicly, under oath, leave marks that don't fully heal. I kept thinking about Danny, who was 38 and taught high school history in Alexandria and had nothing to do with any of this, who was going to have to watch his father and his sister go to war in a courtroom over their mother's money 4 months after she died. I kept thinking about what my mother would have said. She had a way of cutting through family conflict with a single question. She'd look at whoever was fighting and say, "What is this actually about? Not the legal thing, not the money thing. What is this actually about?" And I knew what it was about for my father. It was about 16 years of not understanding where I went, of watching my absence and deciding, in the absence of explanation, that absence meant indifference. He hadn't built this case from malice. He'd built it from a story he'd been given to fill the space where the truth couldn't go. The question I was sitting with, the one that was keeping me up at night in a way that operational stress usually didn't, was whether dismantling that story in a courtroom was the right thing to do. Because dismantling it meant exposing him, not just legally, but personally. It meant standing in front of people who'd known Gerald Calloway for 30 years and watching them recalibrate everything they thought they knew about his family. It meant that whatever came after, even if the legal outcome was clean, even if every number was accounted for and every record was verified, the image he'd spent a lifetime constructing would have a crack in it that hadn't been there before. I had the power to do that. I wasn't sure I had the right. Diane introduced me to my litigation attorney, a man named Thomas Reeves, at a meeting in his Arlington office 8 days before the hearing. Thomas was ex-JAG, mid-50s, with the specific quality of stillness that comes from having spent years in rooms where the wrong word could end a career. He had read the complaint and the supporting materials, and he had one question for me before anything else. He said, "I need to know if there's anything in your professional history that complicates this. Not the classified parts, the shape of it." I said, "There might be." He nodded like that was the answer he'd expected, and then he said, "Okay, here's what I need you to understand. You can win this cleanly. The paper trail on the nursing care is solid. The POA authorization is documented, and we can get an ODNI employment verification that will settle the trust clause issue. That's the straightforward path." He paused. "But I don't think straightforward is what we're actually dealing with here." I said, "What do you mean?" He slid a folder across the desk. "Preston Holt," he said, "your father's attorney. Did you know he was retained in November? 6 weeks before your mother died." I looked at the retention date on the document. November 14th. My mother had her stroke on December 28th. I said, "That's not possible. The estate dispute didn't exist until after she died." Thomas said, "That's correct." I said, "So what was he retained for in November?" Thomas said, "That's what I've been trying to figure out for the past 4 days. He leaned back. "What I know so far is that Holt has a history of doing work for a real estate development group called Meridian Land Partners. Meridian has been trying to acquire a parcel of land in western Fairfax for about 2 years. The parcel they want happens to be adjacent to land your family owns. Land that, as long as your father is on the Planning Commission, has certain zoning protections Meridian needs removed. He let that sit for a moment. A Planning Commission chairman who is publicly embroiled in a family fraud scandal is a Planning Commission chairman whose credibility is compromised, whose vote on a controversial rezoning can be questioned, who might, under the right pressure, choose to recuse himself or resign. I said, "They used my father." Thomas said, "I think someone found a real grievance and fed it very carefully until it became something bigger than it was." I drove home that night and sat in my kitchen for 2 hours without turning on a light. This is the part I keep coming back to, the part that changed the nature of the decision I was facing. Because now it wasn't just about whether to defend myself. It was about whether to expose the mechanism that had been used to manufacture the conflict in the first place, which meant exposing my father not just as someone who'd filed a baseless lawsuit, but as someone who'd been manipulated into doing it, which was, in some ways, more humiliating than being wrong on your own terms. I thought about what my mother would have said. I thought about Danny, who still didn't know any of this, who was probably grading papers right now with no idea that the ground under his family had been undermined by a real estate company's legal strategy. I thought about the fact that Gerald Calloway had genuinely believed, when he signed that complaint, that he was protecting his wife's memory. He was wrong. He'd been helped to be wrong, but the belief underneath it was real. By the time I went to bed, I hadn't decided anything. I want to be clear about that, because I think there's a version of this story where the protagonist has a clean moment of resolution. The parking lot scene, the morning coffee, the sudden clarity. And my experience was not that. My experience was going to bed unresolved and waking up unresolved, and sitting in traffic on Route 50 on the way to the courthouse still unresolved, and walking into the building and throwing up in the bathroom and looking at myself in the scratched mirror and thinking, I don't know if I'm doing the right thing. I just know that doing nothing is also a choice, and it's the choice that lets Meridian Land Partners get what they paid for. The courtroom was standard Fairfax County civil. Fluorescent lights, wood paneling, the smell of old carpet, and institutional effort. Judge Patricia Hale had been on the bench for 14 years and had a reputation for meticulous impatience. She ran tight proceedings and had zero tolerance for theater. My father was already seated when I came in, with Preston Holt beside him. Gerald looked older than the last time I'd seen him, which had been at my mother's funeral. He looked like a man who had been carrying something heavy for a long time and had convinced himself the weight was righteous. He didn't look at me when I came in. I sat down next to Thomas and put my hands flat on the table and looked at the front of the room and breathed. Holt's opening was competent and well-structured and built around the same 3 pillars I'd seen in the complaint: the withdrawal, the employment clause, the absence. He used the word pattern a lot: pattern of unavailability, pattern of financial opacity, pattern of disengagement from family responsibility. He was good at making a narrative out of selected facts. I watched the judge during his opening, and she was watching him with the focused neutrality of someone who was reserving judgment, which was exactly what she was supposed to be doing. My father, when Holt put him on the stand, was not performing. That was the thing that was hardest to watch. He wasn't manufacturing emotion. He was genuinely grieving, genuinely confused, genuinely certain that what he was saying was the truth as he understood it. He talked about my mother's final months. He talked about the bank statements he'd found. He talked about trying to call me and getting voicemail, about leaving messages that weren't returned for days. He said, "I'm not trying to hurt my daughter. I'm trying to understand what happened to my wife's money while my daughter was the only one with access to it." His voice broke on wife. That was real. I looked at the table. Thomas's cross of my father was surgical and brief. He established the November retention date for Holt. He established that Gerald had not actually reviewed the nursing agency invoices before filing the complaint. He established that Gerald had been introduced to Preston Holt by a mutual contact, a name I didn't recognize, which Thomas told me later was a Meridian Land Partners board member, at a dinner in October, 6 weeks before the retention. Gerald answered all of these questions honestly because he didn't know what they meant. He didn't know the shape of what he'd walked into. Watching him answer questions about a manipulation he was unaware of was one of the more painful things I've done in a career that has included some genuinely painful things. My brother Danny testified briefly for the plaintiff. He'd been listed as a supporting witness, though his testimony was limited to confirming the timeline of our mother's health decline. He looked at me once from the stand, and the look wasn't hostile. It was lost. He looked like a man standing in the middle of something he didn't have the map for, which was accurate. I nodded at him slightly, and he looked away. Preston Holt's cross-examination of me was where he made his mistake. He'd built his strategy around the employment clause and the withdrawal, and he was good at both, but he pushed into territory he hadn't fully mapped when he started asking about the nursing agency itself, who had recommended it, how I'd found it, why I'd chosen that specific provider. He was trying to imply the agency was fictitious, a vehicle for moving money rather than a legitimate care provider. What he didn't know, what he couldn't have known from any standard investigation, was that the agency had a contract with the Department of Defense for veteran care services, and that certain aspects of its client records were therefore partially protected under federal privacy provisions that had nothing to do with my clearance level. When Thomas objected and cited the specific provision, Holt went still for a moment, in the way that people go still when they realize the ground they're standing on is different from what they thought. Judge Hale looked at the citation, looked at Holt, and said, "Counselor, were you aware of this provision when you initiated this line of questioning?" Holt said he had not been. Hale said, "I'd like to see both counsel in chambers. Now." What happened in chambers I know from Thomas's account, because I wasn't in the room. Thomas presented the ODNI employment verification, a document that confirmed my continuous service and satisfied the trust clause requirement. And he presented the Meridian Land Partners connection, including the documented timeline of Holt's retention, the introduction through the board member, and financial records showing that Meridian had paid a consulting fee to a shell company connected to Holt 3 months before he was retained by my father. Holt, faced with this in front of a federal judge who had 14 years of experience reading exactly this kind of paper trail, did not deny it. He said, according to Thomas, very little. Judge Hale said, also according to Thomas, a great deal. When we reconvened, the room had changed in the way rooms change when the terms of everything have been renegotiated somewhere you couldn't see. Hale dismissed the complaint with prejudice, assessed sanctions against Holt personally, not my father, in the amount of $51,000, and referred the matter to the Virginia State Bar for disciplinary review. She directed that my legal fees be paid from the sanctions. She did not award defamation damages against my father, and I had asked Thomas not to seek them because that wasn't what I was there for. The referral to the bar was enough. The Meridian connection would become public through the disciplinary process. The rezoning would be scrutinized in a way it hadn't been before. That was enough. I stayed in my seat while the gallery cleared. My father was standing near the door with his coat in his hands, and he looked like a man who had just been told that the story he'd been living inside was not the story he thought it was. Holt was already gone. He'd left quickly, which was the right instinct for someone in his position. Danny was standing a few feet from Gerald, and he had his hand on our father's arm, and Gerald was looking at the floor. I walked over, not because I had something to deliver, not because I had a line prepared. I walked over because he was my father, and he was 69 years old, and he had just found out he'd been used, and whatever else was true about us, that was true too. I said, "Dad." He looked up. His eyes were red, not from crying, but from the specific strain of holding something back for a long time. I said, "The money paid for the nurses. I have every invoice. I should have told you I'd hired them. That was my mistake." He said, "I didn't know." I said, "I know you didn't." He said, "Mara, and then he stopped, because there wasn't a sentence that fit what he needed to say, and we both knew it. I said, "We don't have to do this right now." He nodded. Danny looked at me over our father's head, and his expression was something I didn't have a word for. Relief and grief at the same time, the particular emotional weather of a family that has survived something it didn't need to go through. I put my hand briefly on my father's shoulder, and then I stepped back, and I picked up my bag, and I walked out. I didn't feel clean on the way out, the way people describe feeling after a vindication. I felt tired in the specific way of having made a decision that was right and costly at the same time, and knowing that the cost wasn't finished yet. The Meridian story would become public. Gerald's reputation would survive, probably. He hadn't done anything illegal. He'd been manipulated. But it would be complicated by the association. And complicated things have a weight that simple things don't. Danny would need time to sort through what he'd been asked to participate in. My father and I would need time that I wasn't sure either of us knew how to spend. 3 months later, I was back in a windowless room at a facility I'm not going to name, in a morning briefing that ran long because the situation it covered was more complex than the preliminary reports had suggested. And I was doing the work I'd spent 16 years learning to do, and I was thinking, intermittently, about a text message I'd gotten from Danny the night before. It said, "Dad wants to know if you'll come for Thanksgiving. He's not asking directly because you know how he is. But he's asking." I hadn't responded yet. I was going to. I just needed to find the right answer, which was different from finding the correct one. The correct answer was easy. The right answer was the one that accounted for everything, for what had been broken and what had been preserved and what was still, despite everything, worth trying to protect. My ODNI verification was in a file in Thomas's office now, sealed again, returned to the category of things that existed in official record but not in daily life. I thought about Preston Holt, who had his bar hearing in 6 weeks and whose career was going to look very different on the other side of it. I thought about Meridian Land Partners, whose rezoning proposal had been quietly withdrawn the week after the sanctions ruling, once it became clear that the scrutiny wasn't going away. I thought about my mother, who had looked at family conflict and always asked the same question: what is this actually about? This had been about a fracture that was real and a wound that was real, and a man who had loved his wife and didn't know how to grieve her without finding something to be angry at. Someone had found that wound and pressed on it until it became a lawsuit, and I had spent 8 weeks deciding whether to defend myself or protect my father or try somehow to do both at once. I wasn't sure I'd gotten the balance exactly right. I wasn't sure right was a fixed point in situations like this. I thought about that for a while. Then the briefing resumed, and I turned back to the work, because the work was also a way of being present in the world. And I had spent 16 years learning that presence takes different shapes in different rooms, and not all of them are visible, and that invisibility, done right, is its own kind of devotion.